We're live.
Great. This is the 2nd of March, 2021. This is the hearing of the House Judiciary Committee. And we're going to hear several bills. Today, there are 6 of them with relatively few people set to testify. So let's get started. Delegate Ampry is going to be presenting House Bill 917. He's going to be joined by Christopher Wilson. There are 2 other people who are signed up to testify. I think what would be best, at least a little more efficient, will be just to hear from them on the same panel. With no offense to Delegate Ampry, we can just hear all 4 at once. It's going to help us as we've got a very, very full day going forward. So Delegate Ampry, then Christopher Wilson, Mary Pizzo, and then I have on here Kimberly Haven. Kim Haven is testifying orally. If she's there, we'll add her in. They'll each 2 minutes. The delegate will get 3, and Delegate Ampry, go ahead for 3 minutes.
One quick thing, sorry, Chairman, if I can say, Chris Wilson will not be able to testify today. But we have Saquon Merritt will be testifying in his stead.
Right, Saquon Merritt.
Yes, I believe my team.
Fine, I'm happy to hear them. My reaction isn't to them. It's that we try to keep, we want people to sign up and yada, 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 but I'm not going to waste any time with that. Let's get on with it.
Understood. Thank you so much.
That's fine. Dylan, you want to keep an eye out for that person so that we can get them in the room. Delegate Ampry.
All right, thank you so much, Chairman and members of the Judiciary Committee. For the record, my name is Delegate Marlon Ampry here in support of House Bill 917. This bill is being introduced to prohibit restrictive housing, better known as solitary confinement here in the state of Maryland. It's really here to address the severe psychological effects of those being placed in solitary confinement for extended periods, especially in relation to the effect it has on an inmate's mental state prior to release, which then is contributing to our formerly incarcerated individuals' inability to, get back in society and have a steady and better life. Maryland prisons use restrictive housing at nearly twice the national rate. Of the 19,883 inmates who comprised the average daily population in 2017, 14,578 were placed in restrictive housing. 10,232 of which in disciplinary segregation, with an average stay of 51 and a half days. That's 51 and a half days spending at least 22 hours a day in a 6x9 cell. That's smaller than the average parking space, even the parking spaces we use here in the house. In 2018, 287 inmates were released from Maryland correctional facilities directly to the public with little or no transitional services. These people are coming from an environment where every action is heavily restricted and simply cut loose into a society with no resources or support, in many cases only to be further marginalized. Many individuals who are then released from prison who have been in solitary confinement struggle and have psychological effects that go on for years and years, and sometimes the pain that they've dealt with in that solitary confinement never leaves them. So what this bill would do is this bill would prohibit solitary confinement in the state of Maryland. And what it would do is it would permit solitary confinement only in certain circumstances, in which we are currently amending the bill to do this, where the circumstances would be only for those inmates who suffer from severe mental health issues, to which a physician would prescribe to them that they have to be put into solitary confinement for their own safety, but only for a limited time, and they would get regular checkups to verify that their health is still in a good stance. And those checkups would also be able to verify whether or not they would be able to be released back into the general population. So again, it's really sad when we hear statistics that show that we are above the national rate in which how we treat our inmates. These are humans too. They deserve to be treated fairly. I honestly view this as a form of cruel and unusual punishment when you think about the psychological effects that extend beyond their time after they are incarcerated. And I think as Marylanders, we should ensure that people who go into correctional facilities are not subject to this type of pain and torture, that we are improving their lives. And there's no way we can call an institution a correctional facility if we are making their lives worse upon them going in and coming out. So I ask that the committee extend a favorable report for this bill, and I look forward to hearing from those testifying in support of the bill as well.
All right, thank you very much. What was the name of the person you were going to have? The only person we had in the waiting room was Mary Pizzo. You muted yourself though. Delegate Amprey.
Saquon Merritt was supposed to testify, but if they're not available, Mary can testify, and we'll make sure we have written testimony.
That's fine. All right, we'll hear now from Mary Pizzo, please, and go from there. Thank you. 2 minutes. You're muted, though.
Thank you very much. My name is Mary Pizzo. I'm the supervising attorney for the Forensic Mental Health Division of the Office of the Public Defender. And I was originally going to offer just an informational, but with the amendments that are being made, we're asking for a favorable report. We believe that the use of restrictive housing in correctional facilities should be strictly limited for individuals with severe mental illness. For those with mental illness, restrictive housing, or more accurately, solitary confinement, can be devastating. Many studies have identified the psychological harms of restrictive housing, including self-harm, anxiety, depression, paranoia, and aggression. Restrictive housing is rarely protective of an individual who may be dangerous. The Department of Public Safety and Correctional Services is required to produce an annual report on restrictive housing. The most recent report indicates that the use of restrictive housing decreased somewhat from previous years, possibly as a result of JRA reforms and in the way that they've been counting. However, nevertheless, the report reveals that just over 20% of the prison population was still impacted by restrictive housing. And for approximately 2,406 individuals, individuals in the DOC being treated for severe mental illness in 2019, fully one third, or 812 individuals, were placed on restrictive housing at some point. Of those, more than 75% were placed on disciplinary as opposed to administrative segregation. That means that 634 individuals were punished for being mentally ill. Now, those numbers are for DOC only, but restrictive housing in local detention centers is not uncommon for very symptomatic individuals.
Ms. Pizzo, your time is coming close to an end if you'd like to wrap up.
Yes, thank you very much. Isolation and restriction is not a treatment for mental illness. It has not been found to either reduce behavioral infractions or reduce recidivism, and can cause great harm. So we ask for a favorable report on House Bill 917 with amendments.
All right, thank you very much. I see Saquon Merritt, so we're going to go ahead and take their testimony. Go ahead for 2 minutes. You have to unmute yourself, though. There we go.
How you doing? Good afternoon.
Great.
Thank you for letting me testify. My name is Saquon Merritt. I was unfortunately released. Well, not unfortunately released, but I was placed in restrictive housing when I was incarcerated. I'm a returning citizen. I am now home. I've been home for 3.5 years. And during that time, I was taken away from a lot of the educational accomplishments that I was in the middle of actually achieving. I obtained 38 credits until I was placed in restrictive housing. It didn't really do anything for me. They took me away from all books, all educational formats, and it didn't allow me to grow and do better. It didn't attribute to me being corrected at all. It only put me in a deeper hole and away from anything cognitive that I can do. When I was released out of restrictive housing, I was able to attend Goucher College and do some of the things that were available in the prison facility that are not available in restrictive housing. So since then, since then I'm home. I've started my own business. Have my own company, Lightning Electric. I'm an electrical contractor. And now I employ guys that are being released that were formerly incarcerated in prison. All that was not any contribution to restrictive housing. Restrictive housing only hurt me. So I would ask for us to please pass House Bill 0917 with amendments. You can. and just think of other options. Just think of other options.
Right. Thank you very much for your testimony today. Are there any questions for this panel? Delegate Williams.
Thank you, Mr. Chair. I guess my question is for the sponsor, and it sounds like that you are proposing, I guess, some amendments to the bill, because my question actually was going to be related. I saw the letter from AFSCME with regards to amending the bill, because apparently there are certain instances where individuals will choose to self-isolate for a variety of different reasons. And so I didn't know if you had a comment with regards to that, Delegate Ampry.
Yeah. So I spoke, thank you so much for your question, Delegate Williams. So I spoke with AFSCME today, and we had a great conversation on this amendment. And I'm open to amending it with changing some of the language there. I want to make sure that those who are self-selecting to go into restrictive housing are still not subject to some of the situations that Mr. Merritt spoke about, as far as not being able to access their books, not being able to be part of their classes, limited access to things such as just daylight, or being in a space that's even tighter and more confined, right? So I think there are instances where people feel like they want to be self-isolated because of maybe they have a safety concern issue that they're thinking about, or people just have, maybe they have anxiety around being around a lot of people. We don't, every person that had all the issues that we have right now, people have inside, on the other side. So I'm okay with amending the bill, but I want to make sure that if we are doing self-selection, that people are going into situations where they're not subjected to the same type of the punishment type of solitary confinement, or the medical type that's needed. I want it to be something that's a little different, just to make sure that they're not being removed from some of the corrective and rehabilitative programs that are available while they're incarcerated.
Okay, thank you.
Are there further questions for the panel? Seeing none, we thank you very much for coming today and presenting your bill. That was House Bill 917. Thanks very, very much.
Thank you.
Now to Delegate Pippy, who is back again. Can't ever seem to leave. Don't know why. House Bill 1001, Delegate Pippy, he's the only person who's going to testify. He'll testify for 3 minutes. Go ahead, Delegate Pippy.
Thank you, Chairman Clippinger, Vice Chair Atterbury, Delegate Pippy, for the record, here in support of House Bill 1001. This bill deals with indecent exposure. So I first want to emphasize that there's going to be an amendment. I'm actively working with MCASA, who I'm sure will speak after me, and then MSAA, the States Attorneys Association. What we're trying to address is very simple. With indecent exposure, there are common instances as like someone flashing themselves at a Mardi Gras parade. Then there are egregious cases where someone may go to an elementary school and masturbate in front of children. And what we want to do is, in those most egregious cases, is have an option for a judge to place that individual on the sex registry in the most egregious cases only. And so what we've been trying to do is draft language that would give a judge an option only in those most egregious cases to give an individual the option of being a tier 1 sex offender. We've also had scenarios where people have masturbated on subway trains here in Maryland. And so it's a legally challenging issue, because we don't want to put someone in a scenario where they moon somebody at a football game and they put themselves in a position like on the registry, or again, someone flashing themselves. That's not what we're trying to do. So we are playing around with some language. For example, we have lascivious and prurient intent, which is similar language we used when we passed the child pornography bill 2 years ago. And that helped distinguish between an innocent picture of a child in a bathtub versus a very sexual provocative photo of a child being distributed as child pornography. And so again, what I am going to do is I'm going to present 2 amendments to the committee. One is going to address just children, where you'd have an adult that exposes themselves in a lascivious and prurient intent manner to a child under the age of 14. It'll be a very specific offense. Or I'll have another amendment that will say, if you're an adult and you expose yourself in public to others, children or adults, in a lascivious and prurient intent way, then a judge would have the option of putting you on the sex registry. And I will ask in advance for the committee to work with me on that. And we'll be submitting those amendments and getting those to you quickly. Happy to answer any questions. And hopefully we can come to a middle ground and get an affirmative vote. Thank you.
Thank you very much. Are there any questions for Delegate Pippi? Seeing no questions for Delegate Pippi, we thank you very, very much for presenting House Bill 1001. There's no one else set to testify. No one else set to testify on this bill. So that concludes the hearing on House Bill 1001. Thank you very much. Now we still are getting people coming downstairs from the Economic Matters Committee, and this time it's Delegate Arntz who's coming downstairs to testify before Judiciary, possibly one of the first times he's come and testified before Judiciary. It'll be interesting to find out. Delegate Arntz is going to testify, and then James Moran from Queen Anne's County is going to testify. Delegate Arntz, you're going to get 3 minutes. Your witness will get 2. Delegate Arntz, go ahead.
Thank you. Thank you, Mr. Chairman. It's always good to see you, and we miss you up on ECM. For the record, Delegate Steve Aarons, Queen Anne's County, District 36. I'm really presenting this bill on behalf of the Queen Anne's County Commissioners. It's kind of an interesting bill we've experienced because we have this thing they call the Bay Bridge, the Chesapeake Bay Bridge. We've run into a couple circumstances where we didn't have a way out and we didn't understand how to get out. And all I'll do is I'll give you a little bit and briefly then turn it over to Mr. Moran. The purpose of the bill is to prohibit a person from knowingly and without lawful purpose of obstructing, hindering, impeding, or blocking the use of a highway. And I think Mr. Moran will be able to elaborate on that somewhat. The violation would be guilty of a misdemeanor and a subject to imprisonment, a fine, or both. And it may sound a little bit obscure, but I think after he gets done explaining it, it'll come to light for you. So I yield my time to Commissioner Jim Moran. Thank you. Looking for a favorable response.
Mr. Moran, if you'd like to go ahead.
He's here. I just don't see him.
I see him, but I don't hear him. He's muted. There we go. Some progress. There we go. You're going to have to unmute yourself, though. There we go. 2 minutes.
Yes, sir. Okay. Well, thank you for the opportunity to testify today. As Delegate Arntz pointed out, this bill came about from last year. We had a couple different incidents where an individual would climb all the way up into the rafters, all the way to the top of the Bay Bridge, and park himself there for 24 hours at a time, disrupting 5 lanes of traffic and giving just 1 lane each direction. And, you know, we come to find out through our meetings with the BRAG that the MDTA that there is no teeth to the law. It's basically just a trespassing violation. And what we were concerned with is that this would blossom into other individuals wanting to do the same thing for their, you know, lack of better judgment to just climb up another bridge and disrupt traffic. And our concern became where our first responders are the ones that got to climb up there and bring down this individual or individuals. And, you know, their safety is at heart. We've had, in the last 2 incidences, we've had numerous calls with people that had medical procedures, court dates, even kids going to school stuck in 5 hours in one direction of traffic. So this is just something to give another tool in the bag for, you know, the judges and law enforcement to administer something more than just a slap on the wrist. Because again, last year, this individual that did this did it, and then 3 weeks later did it again. And we're just trying to keep people safe and keep these roads open. I mean, it's kind of, as Delegate Arntz alluded to, the Bay Bridge is in itself a artery for the entire Eastern Shore. So, you know, anything we can do to keep that traffic flowing, keep commerce going, and keep people safe, you know, we are trying to push in that direction. And I thank you.
All right. Appreciate Delegate Arntz letting us know that the Bay Bridge does in fact exist. That's fine. We've taken the Bay Bridge before many times. Are there questions for this panel? I have a very quiet group today. All right. Seeing no questions for the panel, we do really appreciate that you took the time to talk to us today. And that concludes the testimony for House Bill 645. We appreciate it.
Thank you, Mr. Chair.
Thank you very much. All right, it's not even 2 o'clock yet. Well, let's see if we can screw this up somehow. Not with this one, probably. House Bill 1072 with Delegate Deborah Davis. Pre-trial?
I'm hoping
County?
this moves smoothly.
Pre-trial in Charles County? Oh my, that sounds interesting.
Yes,
Wonder if I've talked about that before. Delegate Davis is going to present for the Charles County delegation. We have, I think it's Commissioner Collins who's here. Am I giving him the right title? Okay, great. And then
Commissioner President Collins.
Commissioner President, I apologize. And then Jerome Spencer and Brandon Foster. They'll each get 2 minutes each. Delegate Davis will get 3 minutes though, and she will start right now.
Thank you, Mr. Chair, Madam Vice Chair, colleagues on Judiciary. I am happy to present a local bill for Charles County, HB 1072. It will allow Charles County to establish a community service and pretrial release programs. This was one of my babies from my very first session, as the chairman will attest to. And I'm really excited that we have worked together with the county commissioners, with the Criminal Justice Coordinating Council, with local sheriff's offices and the judiciary to carve out a bill we can all agree on. And like I said, it's simply enabling legislation for Charles County, and I respectfully request a favorable report.
All right, Commissioner President Collins, if you would like to begin for 2 minutes, that'd be great.
Good afternoon, everyone. Chairman Clippinger, Vice Chairwoman Atterbury, and members of the Judiciary Committee. As the Commissioner President in Charles County, I respectfully request a favorable action on HB 1072, titled Charles County Community Service and Pretrial Release Programs. The Charles County Commissioners were informed by our Sheriff's Office that the Maryland Parole and Probation Office recently ceased to provide pretrial services here in Charles County. Recognizing the critical role of pretrial services in our community, we formally request the necessary legislation to administer a pretrial release program. We believe that HB 1072 promotes fair and equal treatment of all persons accused of criminal offenses and ensures their access to liberty and due process is not unjustly predicated on their financial means. We do not believe it is beneficial to our community for persons who otherwise qualify for pretrial release to stay in our detention center awaiting their day in court, while others charged with the same offense, but who are able to pay are able to go free. This bill will give us the ability to establish a program to assess eligibility for release, supervise those that are eligible, and make recommendations to the court regarding services needed to ensure the safety of the community. Unnecessary detention before trial not only results in unnecessary jail costs, but it also deprives the person charged of an opportunity to be productive while awaiting case disposition. HB 1072 will be a valuable resource for making significant improvements in criminal justice within Charles County. Please provide a favorable report on HB 1072. And I'd like to also share, if it hasn't been stated already, Charles County's Criminal Justice Coordinating Council overwhelmingly and unanimously supports this bill. Thank you for your time.
Very quickly, Commissioner President, is the state's attorney a part of that?
Yes, he is. Yes, he is.
I just wanted to be sure about that. Jerome Spencer, would you like to speak for 2 minutes?
Good afternoon, Mr. Chair, Madam Vice Chair, Delegate Davis, and esteemed members of the House Judiciary Committee. My name is Jerome Spencer. I'm the General Counsel of the Charles County Sheriff's Office. I'm here on behalf of Sheriff Troy Berry to express his support for House Bill 1072. Pretrial services has been an important issue for Sheriff Berry for quite a while now, and he very much supports the authorization of a program to be run by the county. Sheriff Berry submitted a letter for your consideration. At the time he submitted the letter, we had not yet seen some proposed amendments to the bill. The amendments appear to address Sheriff Berry's concerns he raised in the letter, and he's very pleased and happy to support this very important piece of legislation. And he also asked you to provide a favorable report. Thank you.
All right, Brandon Foster.
Yes, good afternoon. Thank you, Mr. Chairman, Vice Chair, members of the committee, Delegate Davis. My name is Brandon Foster. I'm the director of the Charles County Detention Center. I'm speaking on behalf of the Pretrial Services Subcommittee of the Charles County Criminal Justice Coordinating Council. We've done a lot of work on this particular issue for quite some time. Currently, as it's been stated here, we don't have pretrial supervision in Charles County. It would be a good addition to the criminal justice system here in Charles County. And so we look for a favorable report. The committee is in support of the bill, and we also are in support of the sheriff's position that this would enable the county commissioners to establish such a program, fund such a program, and the program responsibilities have been established in the language of the bill, and we support that as well as the Pretrial Services Subcommittee of the Criminal Justice Coordinating Council here in Charles County. So again, I thank you for the time to be able to testify, and we are in support of it. We ask for a favorable report. Thank you.
Council is making sure I ask the question, do you have a letter from your delegation?
Yes,
Delegate Davis? Okay.
yes, it's in the file.
And I see it here in the file. So we do. So that is perfectly fine. Are there questions for Delegate Davis?
Are you really asking questions?
Now they are asking questions. So I'm going to ask a question just to get out in front of their questions. I mean, one of the issues that we discussed at the beginning of the interim, Delegate Davis, was I think related to this issue, related to the lack of pretrial in Charles County. Do you want to talk about that just for a little bit, and then I'll hand it over to Delegates Watson and Fisher.
What were the issues that we discussed?
Yeah, I mean, we were talking the issues at the beginning of the pandemic was that there was not really an option for people to be released prior to trial, and this was an issue prior to or in the early stages of the pandemic. And I guess I believe
that one of the biggest hurdles that we had to overcome was who was going to be in charge of it.
Yeah.
Once we hashed out that the sheriff wasn't going to be in charge of it, because he didn't want another unfunded mandate. I mean, I appreciate that. And so once we decided that the county would establish it and house it and work with all the other stakeholders, that we could do it, and we could do it effectively. And another thing that happened was the Criminal Justice Coordinating Council came in and put everybody together, and everyone was able to mesh out their issues.
That's great. Delegate Watson, then Delegate Fisher.
Delegate Davis, the chair has answered my question, and I want to thank Reuben Collins, my dear friend for many, many years, for his continued leadership. Thank you for the bill, Delegate Davis.
Sorry, Delegate Watson. I didn't even know that. Sorry about that. Delegate Juanita Fisher, did you still want to ask a question?
I don't really have a question, Mr. It's already been asked and answered.
That's fine. Thank you very much. Are there further questions? Seeing none, that concludes the testimony on House Bill 1072. Thank you so much, Delegate Davis. We'll now go to Delegate Rosenberg, he is going to testify along with Sandra Johnson of the Falstaff Improvement Association from Northwest Baltimore. They're going to be testifying on House Bill 1075. Delegate Rosenberg will get 3 minutes, and Ms. Johnson will get 2 minutes. Rosenberg, if you'd like to begin with your 3 minutes, that would be just fine.
Thank you, Mr. Chairman. You get 2 Sandys on this bill, Sandy Rosenberg and Sandy Johnson. And I'm here today because of Sandy Johnson. Many of you have no doubt heard of the explosion in Northwest Baltimore in the Falstaff neighborhood. Sandy is the longtime president of the neighborhood, and she had a very legitimate concern. People had died. No one knew for sure what was the cause, and it was taking, justifiably, but it took a while for there to be a report. And Sandy's concern to me was, When will we know what the cause was so that the proper action, if any, can be taken to prevent a reoccurrence? So what this bill would do is require that the state fire marshal, or with the amendment that I've offered today and I trust is before the committee, or the local fire department, local chief, issue a report 90 days, at least 90 days after the incident, that is a public report, and that in a minimum includes the status of the investigation and the expected date on which the investigation will conclude. Let me offer this analogy. When a constituent contacts us about a problem, we want to get a response from the appropriate agency, and the constituent wants a response from us within a reasonable period of time. That's what this bill would do. I don't believe it is burdensome, and I would urge the committee to give favorable action with the amendment, and would now defer to Sandy Johnson to relate how this incident affected her and her community. Thank you.
Ms. Johnson, if you'd like to speak, please, for 2 minutes.
Thank you. I may be somewhat redundant, but I'm speaking on behalf of the residents of the Falstaff community of Northwest Baltimore to support this bill. On August 10th, 2020, there was a well-publicized explosion on Labyrinth Road in the Falstaff community that killed 2 residents and seriously injured 7. 3 homes were destroyed, a 4th was demolished, and countless residents on Labyrinth and Nadine Roads were badly damaged. Some of the residents of the affected area had to leave their homes and go live in hotels. The last one I heard about didn't get back to her home until January 1st of 2021. There may be others that are still not able to return. Immediately following the explosion, I started to get questions from residents who wanted to know what it caused the explosion. Residents in the surrounding area whose homes had been shaken were concerned that whatever triggered this horrible event could happen again in other parts of our community and surrounding communities. I continue to get questions on the cause of the explosion and to raise inquiries with representatives from the Office of the President of the City Council, the Mayor's Office, our state delegates for the area, and the fire department. The answer from all of these sources from August through December was the same. The investigation was still ongoing and they would keep me posted. Finally, on January 11th, I received a notice from the mayor's office of a press conference planned on the update the next day, January 12th. 5 months was far too long to wait for an answer to such a serious question. At our December meeting, residents were threatening to go to the press, and I could not tell them that they were wrong. While waiting for answers, another explosion occurred in the Park Heights area south of Falstaff that increased the concern of residents. The 90-day reporting requirements established in House Bill 1075 are far more acceptable than what we have experienced. As the president of the Falstaff Improvement Association, I can see how our community can benefit from this bill, even if the report was not final. An interim report from an official source is better than nothing. I ask you to support this bill, and I thank you very much.
Thank you very much. Are there questions for the panel? Delegate Rosenberg, just to be clear, the next person to testify is coming from the Office of the State Fire Marshal. Will your amendment resolve their, we haven't heard their concerns yet. But
well, they are still in the bill. It would be the state fire marshal or the relevant fire chief jurisdiction.
Okay. All right. Well, we will hear from him shortly. Are there any other questions from the panel, for the panel? From the panel, for the panel? Seeing none, thank you both very much. Now let's hear from Brian Gerasi from the Office of the State Fire Marshal. He has joined us and he's going to have 2 minutes to talk. I see he's not muted, but his video isn't on. So we're going to need your video on, hopefully. Maybe. Brian Gerasi? Oh dear. Well, he's muted himself and unmuted himself.
There you go. Can you hear me now?
Yes, but we can't see you. Can you turn on your video?
I've had this problem in the past, Mr. Chair. I've clicked start my video, but it doesn't come up.
All right, we're going to let you talk for 2 minutes and we'll go.
I appreciate that very much. And thank you, Mr. Chair and Madam Vice Chair and members of the committee. I'm Brian Gerasi. I'm the Maryland State Fire Marshal. And first, I would like to thank Delegate Rosenberg for his amendments in trying to make this bill a better one, but unfortunately, it still falls short. I know in his testimony, he mentioned state fire officials. He spoke about it in his testimony, but I'm not going to tell you that the Office of the State Fire Marshal did not receive any form of communication from any member of the General Assembly or the general public regarding the row house explosion that occurred in August of last year in Baltimore City. The amendments proposed by the delegate got to me late in the afternoon on last Friday. Now that most of the larger jurisdictional fire departments are included in this bill, they have not had the opportunity to see the bill, nor are they able to testify here today based on the new system that's in place. I can tell you that not all fire departments conduct fire and explosion investigations. It's done in one jurisdiction by the police department, thus putting that fire department in a position where they're unable to provide the information as required in the bill, as they don't possess the information on the investigation. One item not addressed in the bill is criminal investigations. No fire investigation unit or law enforcement agency, for that matter, is going to report on any criminal case where the investigation may be compromised. The sponsors of this legislation have made a big assumption that all the fire investigation units are not providing timely information on investigations. It is clear the Baltimore City Fire Department failed to provide timely information for whatever reason regarding the row house explosion last year in August. Their failure should not throw doubt on all the other fire investigation units, as they are providing timely information on their investigations. In closing, if the sponsors of this legislation had come before us before this bill was drafted and obtained the information they were looking for, I believe that we would not be here today. And I would ask that you go to the House Bill 1075 with unfavorable report. Thank you for your time, and please stay healthy.
Are there questions for those in opposition? Delegate Cardin, please.
Thank you, Mr. Chairman. Just very briefly, Mr. Gerasi, thank you for your testimony. Do you provide a report once the investigation, if you do an investigation, once the investigation is concluded, do you file a report?
Yes, we have a report internally, and we also, after each investigation, we send out every day a notice of investigation to all the media outlets, our social media platforms, to the State Fire Prevention Commission, and to all those else have signed up under Got Delivery. Okay. So we're sending information out on all our investigations pretty much on a weekly basis, unless it's a criminal case.
Right. So you file updates on your investigation weekly, or you only file that information once the investigation is completed?
Once the investigation is completed.
Okay. So the question is, and this is not a question, it's a question of just your policy. Do you have a problem with providing not necessarily substance, but an update on the investigation and the intent of how much longer it's going to take, or whether it's completed or not, and those kinds of updates to the community and to the website? Or you just have a problem with doing anything interim?
No, I don't have a problem doing it. I think we do that. I think we either send out a notice of investigation or a media release that goes out to the public through the media.
And so, if you have substantive information and it's not confidential or in any way can't be released because it doesn't have to do with a criminal investigation, or right. Why would it be a problem? Is there an issue with cost? Or
no, we typically would follow up with something like that if we got more information regarding a case, but typically these cases are done in a short amount of time, especially on an accidental fire. So that information is done and sent out, and really there's no other follow-up information that we're going to get on an accidental fire case or an explosion.
Thank you.
Yes, sir.
Delegate McComas, please.
Thank you, Mr. Chair. Just briefly, and this might be for Delegate Rosenberg or for Mr. Is it Girardi?
Geraci, ma'am.
Geraci. I haven't noticed, but there is a fireman's caucus within the General Assembly, and I'm not sure that they have activated this year because of COVID.
Yes, ma'am, they have. And you should have a letter from them in opposition to this bill.
Okay, but let me ask you this, would you be willing to work with Delegate Rosenberg to see if something cannot be worked out so that at least when these things happen, that the community at least can kind of, I know you don't want to compromise investigations, but can get some kind of notice as to what's happening?
Well, we are doing that. At least in my agency, I'm doing that. As I explained, every investigation, we send out a one-page notice to all the media outlets throughout the state of Maryland, including the DC media. It goes out on all our media, social media platforms with regards to the status of that investigation. Because typically they're done very short period of time. You know, the longer investigations are typically the criminal ones. Accidental ones, such as the case of Baltimore City, we would have sent out a media release within 24 hours of that case if it was ours. So I'm meeting the law right now. I don't need to have something in the law tell me to do what I'm already doing.
Well, I'm just kind of wondering, you know, if, let's say the accident was or the explosion was in the Falstaff area and they have a homeowners association, but maybe some of the residents are older and they're not into computers and cell phones and all that good stuff. And then, you know, they don't watch television or they missed it. I just, you know, just some way to get that information out to them, like just maybe to the president of the homeowners association or something, and they can make.
I think, well, that would be a question for the Baltimore City Fire Chief. I don't have the authority in Baltimore City to do any investigation.
Okay, all right, thank you, sir.
Yes, ma'am.
There further questions? Seeing none, thank you very much. That concludes testimony on House Bill 1075. We're now going to go to the final bill of the day. Whew. House Bill 1110. Delegates. Delegate Rosenberg, you're done. You okay?
Yes.
Okay, that's fine. Delegate Ciliberti.
Sorry.
That's all right. Delegate Ciliberti is our next bill, unless you know, for House Bill 1110. We have Delegate Ciliberti, Mary Zaleski, Lisa Tenney, and Julie Roche that are going to testify in favor of the bill. Delegate Ciliberti, if you are here.
I am. Can you hear me?
To see you.
Here we go.
Need you on video there.
Okay. How are we today?
Well, we're fine, but we need to see you.
Yeah.
Turn on your video.
Okay, here we go. Just a minute.
There he is.
Sorry about the picture, best I can do.
Well, you know, they have to fix this every day that I get on it because I break too ugly.
Okay.
All right, well, so you're doing fine. And Delegate Ciliberti, you're just fine. 3 minutes, please.
All right, Mr. Chairman. Folks, I'm proud to represent or call upon you to consider House Bill 1110. The etymology of this goes back to May of 2018, when I was called by an ER nurse who lived in my district, and she asked me to meet with a group of nurses in the emergency room nurses. And she then portrayed, as did other nurses, some violent activities that go on. A patient was brought into the ER after a violent altercation with police. With the police now. When he was in there, he assaulted an ER nurse. He also assaulted a pregnant social worker who lost her child. All of this, ladies and gentlemen, all of assaulting a police officer before he gets there, assaulting a nurse, assaulting a social worker, who in turn, as I said, lost her baby. And what happens? Well, all of this represented a misdemeanor. not a felony, second-degree felony, a misdemeanor. People in this industry, the hospital workers, people in the ambulances, they all are, not all, many are experiencing these kinds of activities. And basically, we are here to try to raise the penalty to a felony. That's been done in 30 states. That's a felony. There should be zero tolerance for this kind of violence in the ER, this kind of violence in the hospitals, this kind of violence against our nurses. And I assume that's the 2 minutes, and we will go with our wonderful nurses who can give you some more testimony. But I urge you to consider this bill. It's vital. Thank you.
Sorry, I'm muted. Now I'm not. Mary Zaleski, if you'd like, for 2 minutes.
Good afternoon. My name is Dr. Mary Zaleski, and I'm an emergency department nurse. I have been certified to teach a national de-escalation course and co-authored a successful trauma-informed communication course in Baltimore City. De-escalation is not effective against the intent to harm. In August of 2019, I was willfully and intentionally assaulted by a patient. I appeared in court 4 times. The assailant was a no-show twice. After each no-show, a bench warrant was issued, at which time, the next time she came into my ER, knowingly that I work there, when she was discharged, I called and the bench warrants were executed. When the defendant was deemed fit for trial, we went to court September of 2020. The assailant had spent 7 months incarcerated for failure to appear for court-ordered appearance and drug treatment. She stated, "I just want to get out of here." She was sentenced to time served for the assault. 2020 was the year of the global pandemic and year of the nurse. We were hailed as healthcare heroes. The justice system fails to recognize the impact of workplace violence on these heroes. I hear from nurses every day who are leaving Baltimore City and the emergency department. Their families are in fear for them. And the misdemeanor penalties may be the same as a felony penalty, but the judges are not handing them out. I ask for you to support this.
Okay, Lisa Tenney for 2 minutes, please.
Hi, my name's Lisa Tenney, and I'm the chairman for the Emergency Nurses Association in Maryland. And I'm testifying on behalf of them. And good afternoon, everybody. It's good to see you all again. Workplace violence against emergency nurses and healthcare providers is a national epidemic. You've heard me say that before, and OSHA has found that U.S. healthcare workers are 4 times more likely to suffer workplace violence than any other occupation. 100% of emergency nurses have experienced verbal abuse from our patients. 82% of nurses and 75% of the ED physicians have reported physical assault. This is what's so heartbreaking. 80% of the physicians say that ED violence harms patient care. And of those, more than half said patients have been physically harmed as collateral or as a direct result of other patients acting up. We know that ERs are special places. There's lots of reasons why the violence occurs there. What has been happening more and more is that the police bring in a lot of people that they are arresting for medical clearance prior to taking them to jail to make sure that there is no mental health issue and to make sure that there is no physical issue. And we do take care of them, but it does increase the number of people that we see. We know that ER waiting time in Maryland is one of the highest in the nation for a variety of reasons. People get frustrated while they're waiting and they act out. While Maryland passed the Workplace Violence Prevention Bill in 2014 and has been hailed as a leader in prevention of workplace violence, we have failed to do what the other states have done, is that if for some reason there is a failure to prevent it and it does occur, we don't send a zero tolerance message. And we need to preserve the health of the patient, the other patients that are there in the ER, and for our the healthcare workers. This bill makes sense attaching it to 3-203 because we are right there with the law enforcement, EMS, and us. It's a continuum of care. We all work together side by side, but for them, it can be a felony. For us, it's not. It's a misdemeanor. So thank you so much.
Thank you very much. We're looking for Julia, who was on, and then, oh, here she's coming in. Okay. So we're waiting for Julie. I'm going to assume it's Roche. Hopefully we'll hear from her shortly.
Her Zoom timed out and she's reconnected.
Okay.
Bingo, here we go.
All right, Ms. Roche. Ms. Roche?
Am I unmuted now?
Now, there you go. Okay, good. All right. You can have 2 minutes of just cheering, but we'd prefer to hear your testimony for 2 minutes, please.
Okay. As an emergency nurse, I've had multiple encounters with violent patients. The most horrific encounter was when I witnessed my coworker rabbit punched in the back of her head at approximately 26 weeks pregnant. Subsequently, she lost her baby. I went with her to the trial where I watched the perpetrator, who had a cumulative sentence for all that he did that day of 35 years, on the table. And I watched that reduced to 10 years. He is able to be released in 5 years for good behavior. The reason he got 10 years, the police officer who was bringing him into the emergency department was assaulted. That's the only reason that the 10 years was not able to be taken away. He was protected by a felony assault with a mandatory 10-year sentence. The other 25 years were commuted. These were multiple attacks within the community before he was brought into the emergency room. The only thing that protects any person that is in the way of this man in our emergency department is a felony charge. That's the only way. He told me while I was his nurse that he couldn't help himself and that he will kill someone. I think that the only way that we can stop violence is by promoting that the truly violent offenders are imprisoned for horrific acts. Why are the innocent the ones that should suffer the consequences? Violence like this is just what a felony assault charge is there for. Please, I beg of you, protect our healthcare providers so that we can give the patients the care that they deserve. Your family member could have been in that emergency department when this happened. It happened in front of multiple people that were being treated. It takes the care providers away from taking care of the people that they're there to care for when they have to run from even in the
Ms.
instances
Roche?
of cardiac arrest. Yes, I'm sorry.
We need you to wrap up. That's okay.
Okay. So anyway, as a nurse, we take an oath to protect our patients. I am here today to uphold that oath.
All right. Thank you very much. Are there questions for this panel? Are there questions for the panel? All right. Delegate Grammer. Oh, Delegate Grammer has to start over again. For those who are new to the call, Delegate Grammer has a unique sound issue with his computer, and I'll take up some time to give him the chance to jump back on the Zoom. But sometimes it forces him to sound like a cross of Alvin and the Chipmunks and Donald Duck, some kind of controlled dangerous substance all at the same time. And so that is not Delegate Grammer. Delegate Grammer just has a faulty microphone. So we are working on that, and we're going to let him join again back. But it's been a couple weeks since we've had that happen. So I almost was missing it. But does anyone else on the committee have any questions while we wait for Delegate Grammer to get back? Here he's coming back. Let's see if it works. If it doesn't.
You're a gracious chairman, Mr. Chairman.
All right, let's try this again.
Oh,
is it working?
It's working this time. All right,
Okay.
Delegate Grammer with a question.
I was just going to type it, but can you just give us a sense of how often this occurs in hospitals, in healthcare facilities? Is this something where we see it once a week, or it's really bad on a really rare occasion? Because I'm hearing more of this even from my district. Can you just help us get some perspective, please?
As far as I know from what I have read and what has been told to me.
Delegate Siliberti, can we hear from the nurses, please?
Oh, I'm sorry, excuse me.
I love you, but let's hear from the nurses.
I'm not a nurse and I yield.
I can tell you that just in the month of February, there were 5 major events in the nation that made the news. One person in Buffalo, Minnesota, one nursing assistant was killed just last week. A physician in an ER at Penn Med in Philadelphia got stabbed in the head and the face several times. It is, and there were 3 other events that I'm trying to dredge up, but there were 5 just in February. For us, and Mary works in, Dr. Zaleski works in Baltimore City. I'm more in suburban Maryland. We see the violence every day. It is not, our preventative measures help us, but in about, I would say about 1 1/4 people that come in, they don't want to be there, and it's even worse when the people that are brought in by the police are being evaluated. So, someone else can speak.
If someone wants to speak just to Maryland, please.
Mm-hmm.
Okay, related to Maryland, I can tell you from my experiences in the ED, I have seen multiple between my ED experience in Montgomery County and in Frederick. You learn to dodge chairs, you dodge fists, you learn to keep people from attacking other patients that are there. It's just multiple, and people don't come forward because they are scared. They know that they're going to go in there to court and that it's going to immediately be thrown out. They're never listened to. To watch, I was the only person that went with my coworker to court, if you can imagine that, to watch her with her witness statement against this offender. People are too afraid to, and we just need this protection desperately.
Okay, thank you so much.
Delegate Chan. Oh, I'm sorry. Go ahead, Dr.
I can tell you from working in Baltimore City, as I said, 2 open bench warrants. She came into my ER. She sat there. She smirked. She laughed. She dared anybody to do anything because nothing is going to happen. I see violence on a daily basis in the ER.
So do I. And the statistics for it are, we use the ones mostly from national. In Maryland, what we have to do, thanks to the bill that was passed in 2014, is that hospitals have to have a robust reporting system and tracking system and risk mitigation process, as well as de-escalation training. And almost all of us now have what's called behavioral health response teams. In my ER, we have what's called nurse duress buttons, which a couple years ago when we testified before your very committee, University of Maryland passed out their buttons so that we could call for help. That's how frequent it is. And we also have off-duty law enforcement officers there. So it's very prevalent, and it doesn't fall along racial lines. I can tell you that. It is bad people acting badly.
Delegate Cham.
Thank you, Chairman, and thank you to the nurses who are here today. We appreciate the hard work that you do in the emergency rooms. I'm sure it's a new encounter every day. No day is the day before. So the question that I have is for you regarding the people that come into the emergency room and they are engaging in really dangerous behaviors. Is there a documented disability? Are they under the influence of some type of drug? What is the kind of, what do these people look like as far as cognitive abilities and or?
I can tell you in my emergency department, they come in, we do have patients who come in acute psychotic breaks. They're not in control. They're not able to manage their behaviors.
Like a documented disability or something has occurred that has caused that.
Right. An acute psychotic break is a medical emergency. They don't need to go to jail. They don't need to be arrested. They need to be medicated and they need to be treated. Geriatric dementia patients, one of the most severe injuries I've ever had was a little 92-pound elderly lady who clocked me and almost knocked me out. Was she in control of her behavior? Not at all. Would she be charged? Never. There's not a nurse I know that would charge someone who has a medical or even a psychiatric reason for their behavior. We come to work to save lives, to hold hands for the people that are passing on to their next life, and we're their only comfort. Part of that is dealing with acute psychotic breaks, dealing with our geriatric dementia patients who are swinging at everybody. That's our job. This would only pertain to those who are knowingly and intentionally harming an emergency worker.
And you have a disability and still knowingly and willingly engage in aggressive behaviors?
I would depend on the disability. If you're having a documented, you may have a disability, but you're not having a psychotic break, you're just angry, you attack your family, you attack police officers, you attack the staff, that is not an acute psychotic break. That is not an acute psychological issue. That's an escalating issue. And depending on the extent that you are injuring people, if somebody is having an acute psychotic break or they're under the influence of drugs and they willingly get in their car and drive and run over my family member, I really don't care about their disability or that they were under the influence. They're legally responsible for their actions. Not all disabilities excuse you from responsibility.
Thank you. Thank you, Dr. Zaleski.
Delegate Deborah Davis, please.
Thank you. I would like to follow up on Delegate Cham's question. How does the law, as written, distinguish dementia patients, people who are in the middle of a psychotic break, people who are overdosing? How does the law, and what other instances would you say shouldn't be covered by the law?
We're not lawyers, and I usually, when somebody asks me this question, it is usually up to the practitioner to decide whether they're going to press charges. And as clinicians, we know the difference between someone who has an organic problem going on, something metabolic, and somebody who has sat there and said, I'm going to hurt you. And but we would defer to the law and to the lawyers. I usually have said to judges, you know the law. If you were the one that got hurt in this courtroom, what would you do? It's the same for us. You're trying to do your job. We're just trying to do ours. And if we know that it's a medical disability, like little kids autistic kids that act out, they're our patients. We just take care of them. So how that gets differentiated, I don't think any of us clinicians can answer that, because we are not also lawyers.
Are there further questions for the panel? Seeing none, we thank you very much for your testimony today, and thank you for coming to speak with us.
Thank you.
Testimony for House Bill 1110. That concludes at 1 hour and 10 minutes in the hearings today for the House Judiciary Committee. The Public Safety Committee will be meeting at 4:30. 4:30. It's a change in time from 3:30 to 4:30 today. The Vice Chair will be running that committee. I don't think there are any other subcommittee announcements right now, but we will be announcing those by email. Thank you all very much for being here today. We stand adjourned.